Hello, hello. Hello, hello. It's Verdict Watch. It's Verdict Watch. Good morning, good afternoon, or good evening, wherever it is you all are streaming this live stream from. Let's calm that down a little bit. Good morning, good afternoon, and good evening. This is Pamela, and you are watching Pam Entertainment TV, where we review movies, television series, and incidents in pop culture to see how those incidents may or may not affect our daily lives. Listen, you see me, you see it's early. You know I don't get up this early. I work in the evening, but I'm here. We are here to do a verdict watch, and basically this live stream is limited, but it doesn't have a whole lot of structure. And basically what I mean by that is uh we will be on here probably 30 minutes, no more than 45 minutes, and we are going to go over the information that we know. I'm going to be looking at the chat to see what you all are talking about. Leave your comments, leave your questions or anything like that that you would have. Uh, we're because the jury has everybody rested the other day, and I apologize for I was supposed to do a live stream last night, but for some reason I thought last night was Friday. And I was like, I don't really do live streams on Friday. I'm not gonna do. And then I realized, no, Pam, today is Thursday. I don't know why I thought that the jury wasn't going to meet to 2 o'clock on Friday. So I was like, I mean, on Saturday. So I was like, and I can imagine they're not going to meet early in the morning on Saturday because they want to be able to get up and do what they got to do in their day and then go deliberate. But charge it to my head, not my heart, child. It's a mess. It's a mess. It's a mess. All right. So what I wanted to do this morning, first of all, let me see who's here. Hello there, Gray. Good morning, Terrence Thompson. Good morning. Good morning, Casey Reeder. You're welcome. Elijah joined. Come on over here at Twitter. All right, James. Good morning. Apricots. Oh, I like that name. I like how you spent that name. I love your name. We appreciate you too, Apricots. I like your name. All right. So you all have joined this morning. We are really looking at the verdict watch and what the jury has been charged to do. They have been charged to judge this man on the actions that happened on March 25th, 2023. And so right now they are I think they have some more instructions to get, and then they're going to deliberate. So don't quote me, because like I said, yesterday was a real wonky day, and I went through the day and I heard a lot of the stuff, but I didn't hear a lot of the stuff, and that's just to me. But they are going to be deliberating. So what is it that you all are thinking? I am thinking this. They have three charges, if I'm not mistaken. They've got assault with intent, reckless assault, and harassment to go over. What are you all thinking in the chat? What are you all thinking? Is it so it's the intent, the reckless, and the harassment? Intent, the reckless, and the harassment. From the information that has been put out now, because we've seen the evidence that the jury saw. And we're going to speak on the evidence that the jury saw because that's the mindset that we're worried about. Uh, with the information that the jury has seen, how do you think they're leaning? And I'm asking this question, and I want you to use your thinking cap. Think with your heads, not with always just our hearts, but just think about it. He's got the intent, he's got the reckless, and he has the harassment. From the information that we know, from the evidence that they released the other day, this is the information that the jury has and that they're able to utilize in their deliberations. So, looking at the information that they have, I saw somewhere, hold on, y'all. with the information that they have, what are you thinking? So I see here, see if I can read it. So assault in the second degree, physical injury intent with weapon. This is penal law from New York. The specified count is assault in the second degree. Under our law, a person is guilty of assault in the second degree when, with intent to cause physical injury to another person, he or she causes injury to that person or to a third person by means of a deadly weapon or dangerous instrument. The following terms used in that definition have special meaning. Physical injury means impairment of physical condition or substantial pain. Intent means conscious, objective, or purpose. Thus, a person acts with intent to cause physical injury to another when that person's conscious, objective, or purpose is to cause physical injury to another. And then it goes on about the deadly weapon and the dangerous instrument. And there was no weapon or instrument used that we saw on in that case. So then I wanted to get to, I moved it. Hold on, y'all. I had my stuff queued up. Harassment in the first degree. A person is guilty of harassment in the first degree when he or she intentionally and repeatedly harasses another person by, wait a minute, harassing another person. Hold up. I see cats coming in. Come on, Kat. I'm just reading out the definitions here. Harassment in the first degree. A person is guilty of harassment in the first degree when he or she intentionally and repeatedly harasses another person by following such person in or about a public place or places, or by engaging in a course of conduct, or by repeatedly committing acts which place such person in reasonable fear or of physical injury. This section shall not apply to activities regulated by the National Labor Act and, well, anyway, Employment Act, such and such and so there is. And then it just says harassment in the first degree is a Class B misdemeanor. Now, was he charged with the harassment in the first or the second degree, Kat?
I don't know, actually. I can pull up all four.
Thank you. While she's doing that, I'm going to give you the harassment in the, I read the first. Harassment in the second degree. A person is guilty of harassment in the second degree when, with intent to harass, annoy, or alarm another person, he or she strikes, shoves, kicks, otherwise subjects other persons to physical contact or attempts or threatens to do the same, or he or she follows a person in or about a public place or places, or he or she engages in a course of conduct or repeatedly commits acts which alarm or seriously annoy such other persons and which serve no legitimate purpose. So we have Kat here. Kat, if you don't mind, because like I said, I was discombobulated yesterday. I don't know why I thought yesterday was Friday, and the jury was going to deliberate at 2 something on Saturday, because I was like, well, that makes sense to me because they want to
get it done with. They want to get it on.
They want to get their day done and then go in and be through. And then I realized I set it up for 11:30. I'm like, girl, you go to work at 12.
Oh, I never know my time zone, so
but could you briefly go over for the audience about what happened yesterday about the closing arguments from both sides, and what did you get from those closing arguments?
Okay, so we're obviously only working with quotes. I pulled quotes from like 8 different people, so because it's hard to type really fast while you're in the courtroom. But the overall gist, and by the way, it was defense went first. It was Priya Chaudhry, and then Kelly Galloway delivered closing arguments for the prosecution. And the defense's take, to me, their argument is, on one hand, why would Jonathan Majors, if he committed these 4 things that he's being charged with, why would he go back to his apartment, find his ex-girlfriend laying there unconscious with a cut on her ear. And they said that part out loud to emphasize that that's when the cut was found. And then call 911 on himself. And then also tell police that they had an argument the night before. So that was one part of their argument, that it just doesn't make sense. And then they really went in, they did some stuff to attack her credibility and the injuries, because part of the charges is impeding an injury that causes some type of impeding of motion or substantial pain. So we don't have specifics, but I'm sure they highlighted how the prosecution on direct kept trying to ask Jabari, and did you feel pain? And we had Danny tell us that she, like, for whatever reason, she kept being like, no, I just felt adrenaline. So that's important, because part of the language in that charge is feeling substantial pain. And then they went on to talk about, the driver, what the driver saw, and how the injuries weren't consistent based on the cross-examination and their own expert witness testimony, the trauma doctor. And then they went on the line of attack about how the prosecution, the DA, and the police have approached this case. And that's where they come in and say, we're here essentially because they saw her white lies, they took them and looked at this black man and just believed her white pretty lies. And that's, of course, the snippet that the major news outlets wanted to focus in on, right? That Priya Chaudhry's whole argument is just that she's calling some white girl a white crying liar with no basis for it. But she laid that out. And then the prosecution gets up, and they're all over the place, in my opinion. For me to see so many inconsistencies in someone's closing argument when we only have a limited amount of quotes for me to even see was kind of shocking to me. But and Babette has done great work on this. ADA Kelly Galloway is very new. She's been at this. This is probably like her first major. It's like a misdemeanor, but it's a lot of eyes on it, so it feels bigger, right? So she just seemed like, to me, she was up there. She was talking about how the defense was using Darvo tactics against Grace Jabari. Not that Jonathan Majors engaged in Darvo throughout their relationship, because I'm sure she wouldn't have been allowed to say that. But she was able to say in closing arguments that the defense team, through this whole legal strategy, was using, I think it's deny, attack, reverse victim offender is what Darvo stands for. Basically saying that the defense team, their strategy was to convince the jury that the abuser was the victim and the victim was the abuser. So they follow that line for a while. They do bring up the Coretta Scott King audio. They play that again during closing arguments. Then they reference the text messages, but everybody who described this mention of the text messages alludes to it being a very vague reference of things he did in the past. Because remember, the jury still does not know that these text messages are from that September 2022 Coretta Scott King phone argument. So they still had to be really careful about that. They also said that their sole witness, they called the driver, Sarwar Naveed, their sole witness. And then they say he's unreliable, even though they bear the burden of proof to prove their case beyond a reasonable doubt. They get up there and tell the jury, don't listen to our sole witness, the only person in that car besides the two of these people, Jabari and Majors, that has any idea what was happening in that car. And then also, you're only here to determine what happened at that car, where Jonathan Majors was throwing Grace Jabari into the car like a doll. So
A football. Didn't they say a football?
They changed it now. Now it's a doll.
Oh.
Now it's a doll. So, and then they also reminded the jury, which is legally and factually true, that this is not Grace Jabari versus Jonathan Majors, but that it is the people versus Jonathan Majors. That is what it is. But I'm not sure why they were emphasizing that, because to me that seems like you're suggesting maybe you're getting the sense that the jury doesn't find Grace Jabari credible, and you're reminding them that it's not about her credibility, when it is, because she's
all about her credibility.
She's your background story witness. She's your fact witness for this pattern of abuse, right? And then at the same time, why would you want, you've had all these credibility issues with the police department. They don't recall anything. They recall different things. They didn't take any evidence. And the police department is part of the people. When you say the people, that includes all of that.
Yes, they're
So
supposed to investigate.
so why would you want to emphasize to the jury it's us, me, the prosecution, and our police that did this shoddy work versus that guy sitting over there by himself, just one person. So to me, that was a weird strategy for them to emphasize. I think they were trying to take the spotlight off Grace Jabari's inconsistencies. And then in the next breath, they try to tell the jury that Grace Jabari was consistent. And the one example they used about her consistency is the fact that she kept saying that she was chasing Jonathan Majors because she just wanted to know who that woman was. So they're emphasizing Grace's own reasoning and testimony that I think hurts their case as an example of her being a consistent and thus credible witness. And that's the only example they give of her consistency.
Yeah.
And, you know, then to tie it up, they mentioned, you know, the spiel about victims don't always act the way people would expect them to, which is true, but that's applying a broad stroke expert opinion lens over this one individual situation. So
Right.
if the jury is, you know, inclined to apply that here, then maybe that was a good argument. But if they're wondering, how does that relate to this video of him chasing him? You're just telling us that we're supposed to accept that she's chasing him because not all victims behave the same way. True enough, but I don't think that's the case here. From what I read, I don't think Kelly Galloway was prepared for this. So
and hear me, like I said, all victims do not act the same way, but all victims act in a way of self-preservation. They will do whatever they need to do for self-preservation, even if it seems odd. And what I mean by that is, if they're standing there with a whole bunch of people and they feel threatened by this person, and you may see them go over to that person and stand, well, that seems odd. Well, it's not, because you're not looking at the visual cues that that person is doing, right? This doesn't seem reasonable. You are getting out of the car, and once you're out the car, we see you. Let me see if we can watch this on TMZ. I keep pressing the wrong thing. But you're chasing after him. Reasonable people don't chase after people like you chased after people. That doesn't seem reasonable. Because I think you mentioned it in the
language was fear. You were just reading the belief of fear.
Right.
And from her demeanor, there's testimony about it too. It's not just the appearance on the video. So, right, the video is evidence, and any testimony about someone's demeanor is also evidence, where you can look at someone's body language and discuss possible intent or state of mind or belief, reasonable belief that that person held during that moment in time. And they're emphasizing that in closing too, that I left that part out, that, you know, they're trying to emphasize this whole idea that on the moment outside of the car, that there's some intent behind what he's doing because of some facial expression that he made while he's shoving her. And I heard Danny say that there are some other angles of certain points in the footage, and I don't know if that's the exhibit. According to the Roland Martin show, Lauren Burke has been in court as well, and they played the video of the chase scene. It was the compilation video. And they say on the Roland Martin show that this is the video that they requested. So I don't believe they just requested like a bird's eye view of right at that car door where he's picking her up. I think they requested the whole chase compilation, which is a little bit different, right? If they're asking to see the whole video, we can't pinpoint why.
Yeah.
But
yeah, because if you look at it, and you were talking about the reasonable, basically the threat, if you're scared, your threat, your fear at that point ran down the road. I mean, if you wanted a level of safety or felt like you were safe, you would have gotten back into the car. And like you said before, got in the car, and if you wanted to, have him, you know, chase to see where he went or take you home.
Or sat in the car crying I can be a crybaby. If I wanted to see that phone, I would be chasing, and that would be aggressive on my part. If I just got hit and hurt, I'd sit there crying, and the driver would probably have to just sit there blankly until I was able to say something and figure out what I wanted to do.
Yeah,
There's a
because you're
difference, and it's
and you're in the
called
middle of
fight
the
or
street.
flight. It is not
Yeah,
fight and flight. There's
yeah.
no it's not the same.
It's not the same. It's one or the other. Because you could have sat in the car. There was no need, but that signifies to me that there was no fear. There was anger. You weren't fearful, you were angry. And that's what fueled
And we
your
have her testimony, like, that's her testimony too.
yeah,
This is not just video evidence here, we have testimony. And we have no testimony from the driver saying he thought that Grace Jabari appeared fearful, or Grace Jabari appeared to be, having a demeanor where she was in substantial pain. So remember, the anytime you hear any questioning about and what was their demeanor at that time, that's usually to establish things like intent and state of mind. That's the way they're able to ask and establish that type of testimony evidence.
and and I think about when she testified that she said, "Oh, well, he hit me in the back of the head." And they were like, "Well, did you feel pain?" No, I just, did she say something? I don't want to say
She kept saying she didn't
I just felt
see.
his weight. I felt him
I
on me.
felt like he was trying to make me feel pain is one of the things, and that's quote. I've read that so many times. I felt like he was trying to make me feel pain.
Right.
So you're not saying even when you mention the word pain, you are not saying you felt pain, and it's supposed to be substantial pain. That is the language in the charge.
Yeah, because substantial pain is he hit me across my
Impeding,
head.
you don't
It,
chase him and keep grabbing at him with the hand that hurts,
well,
or
if you've ever been hit, uh, listen, if you've ever been hit, the first thing is like, yeah, I felt pain because I felt ringing in my ear. I felt I felt like I was going to pass out. I mean, it was excruciating, but not. I felt like he was wanting to make me feel pain.
and then I still didn't. I just felt adrenaline. Like she had so many opportunities to say she felt pain. And I don't know if it was, she was trying to get ahead of what she knew was coming with the Lucy's videos all the time she was using her injuries.
Right.
So, and
Blue,
I would
hold on.
imagine she should have been prepped on that, but
Hold on just one second. Blue, are you still in here? I remember you had a conversation. You were talking with Dre one time and you all were talking about football injuries and stuff like that. If you're still in the comments, just tell us, or if you want to come up, I can put the link in the thing and you could come up. But tell us about this adrenaline. And I know we've all had adrenaline and stuff like that, but I've just never seen people or heard people talk about I just felt adrenaline. What does that feel like? Is that like a caffeine high? Y'all explain that to me. If anybody in the comments can explain that to me, if you can explain that to me, Kat, what does that feel like? And I'm not nitpicking, but I really would love for us to have some kind of idea of I just felt adrenaline. I just felt
I think she had a
adrenaline.
pump in heart because she was angry. I think what she was feeling was a different type
Thank
of
you.
adrenaline. I don't think the cause was adrenaline from being struck or injured in the process of whatever was going on. Because again, I think even if one of those injuries came from when he's putting her in the car, I think they misplaced the assault injury then, because if they're trying to attribute the finger to have happened inside the car. And I haven't seen the jury instructions, and I would love to because that's one of my favorite things to look at. But I'm sure both teams had to argue the language that was included, and it should be in there when they're alleging the exact instance where the mechanism. So pulling the finger, that should be tied to the appropriate charge. Do you think that in the instance where this finger was being pulled, that language should be in jury instructions? And we have testimony from Grace Jabari telling us exactly when she says that occurred.
Mm-hmm.
She testified to it and she repeated it more than once, that it was in the car during this moment with the struggle over the phone. So they can't turn around now and say, well, jury, you can also decide that maybe her finger got broke because he was grabbing her and bent her finger in that process. They have to follow the mechanism that was tied to the charge,
Right.
which is why you kept hearing that word mechanism through every time they talked to Dr. Xiang and the trauma expert, Tammy Weiner. It's the mechanism because that's tied to the specific charge. Harassment, not so much, because that can be a little bit more encompassing because it's not involving a specific injury. But I would say the adrenaline is just, she had that adrenaline since moment one when she saw that text message there, before she even struck him, as she said, to start the fight. That adrenaline was already there.
Yeah. Yeah, she was already upset. Like I said, she was already upset. How does because one of the things, and I think if we're for me talking as a reasonable person, a lay person, one of the things that I'm wondering how this plays into it, because when someone takes your stuff, or when somebody is threatening you, or when somebody hits you, or stuff like that, you have, I mean, the law doesn't say, oh, you're just supposed to allow them to hit you and not have enough, do enough reasonable efforts to either get your stuff back or to or to defend yourself. And I remember that the driver basically testified she was doing it. She was doing it. She was doing it, which indicated to me that she was the one who was
The
doing it.
outward movement, the
Yes,
obvious motion is coming from her body, and
exactly.
anything restrained is probably and unvisible, less visible, less space encompassing is him.
Right. Where does that, I wonder, do you think that they're going to get instructions about uh having the a reasonable amount of I'm saying force, but a reasonable amount of effort to be able to retrieve your stuff without it, like, after, if someone grabs my phone, I can reasonably do what I need to do to get the phone back, but once I got the phone back, I can't uh continuously use the force that I was using to get the phone back, because now I have the phone back. And
Sort
you
of, unless they're causing you or you have the perception that they're about to cause you like great bodily harm. I mean, you do have the right to self-defense in that case.
got you.
Um,
That's
and but that can always change at any moment too, right? So if that continues for 1 minute and they're hitting you and you're able to, within the lines of the law, fight back because they're hitting you, but then they up and say, I'm done fighting, and they take a step back and you continue and you're like, no, I'm going to keep going now. That can change. The definition of self-defense and what qualifies can change with one person changing their demeanor, intent, or perception in that moment. Like, just, it can go
that's
back and forth. It can be self-defense for both parties. It can be
mhm.
self-defense for one, then it can be self-defense for the other. It constantly evolving, even in the frame of a few seconds. So
Yeah. What do you think the jury is, if you, from, because I had placed this to the people in the chat, if you were presented with the evidence that the jury was presented with, what would be what I mean, going through each charge, what would be like a piece of a video, a piece of information, or anything like that that you would key in or key out of, uh for those charges? Like, for instance, like the intent charge, what would key you in to say this was intent, or what would you key in, I don't see the intent there? I hope I'm making sense.
So it's my understanding, and this again would have to go to what's actually written in the jury instructions, but it's my understanding that the two assault charges are regarding a mechanism of injury that was stated to have taken place inside the vehicle. So inside the vehicle. Then the harassment involves what happens at the vehicle, meaning the doorway where in that moment he's picking her up and trying to put her in the car. Now there is some language that in the codes that can say
Mhm.
on or about this time. So that can be confusing to the jury where they might read that and say on or about when that means we can look outside the car too. But I don't know if there's any clarifying language in the jury instructions on that. But that
Yeah.
being said, when it comes to the assault, if I want to do my due diligence as a juror and I'm being told that the assault is what happened inside the car, then I'm going to sit there with my peers on the jury and say, well, if we can only look at what happened inside the car and we only have Grace Jabari, we didn't have Jonathan Majors testify. We only have Grace Jabari and we have the driver. That's what I got to work with. And if I'm working with that, if I remember, because remember, we have to go off what these 6 jurors remember and are able to volunteer to discuss with each other. If they're sitting there quiet and they're the only one that remembers Jabari saying, I started the fight because I grabbed the phone, the other 5 jurors might not be considering that. You know what I mean?
Hmm.
They're not like us who have been sitting here repeating it over and over and over. But all it takes is one person to remember, say that to the rest of the jurors, and be like, well, yeah, I mean, she started it in the car. And then the driver did say it sounded like he got hit. And in that moment, I would sit there and imagine what it would sound like for someone to get hit. If they got hit in the gut, it'd probably be like, ooh, you can kind of see that it, when someone says, I knew because I heard it, you can see how that might be true because there
Right.
are sounds people make when they are hit. And then I would work from there to be like, At best, if we can't decide that she definitively started the fight, we cannot decide that he did, which means we're in that reasonable doubt pool. So for
Okay.
me, I couldn't get to beyond a reasonable doubt for inside the car. What I think might be an issue is someone that thinks he should have ran away instead of ever trying to put her back in the car. And I don't think that will be all 6 people personally. But what could happen is all 6 people want to get out of there and they say, hey, you know what? You're fighting really hard on this one harassment charge for what happened outside of the car. And we'll give you that one. The other 3 are not guilty. Split verdict, compromise, and we get the hell out of here.
Yeah.
Because we don't imagine that charge ruining this man's life, but people can't complain about it on the flip side either. So that's kind of the worst case scenario, I think, is a split verdict on one charge. That's what I see.
Okay.
Otherwise, I would think not guilty.
Yeah. I think so too. And when I was reading that harassment, it is
It is confusing.
it's
It gives them
confusing.
an easy way to say, let's give it to him. Let's just give it to him because it's
Yeah.
confusing.
It's confusing and it's loose. It's loose. All right, people. So I've got 10 more minutes on here. We thank Kat for being here. Listen, if you all have, I'm going through your tweet, I'm going through the comments down here, um, just to see if there was any. They didn't talk about that, did they? And I'm gonna go back over with you because this no, that's not the here. This is what I was looking at. The text messages. You remember the text message before the one that he read in the 911 call about no one will know it's you. Did they in the courtroom? I don't remember if Danny spoke on it or not. Did they talk about those texts that were up above that? The 32 calls, the 15 texts or whatever. Did they mention it?
So I believe that they have 4 images of a phone screen's worth of text messages. So it was more than like I think the first day when it released, like the main ones floating around were like the first response from her about telling the head hurting and then the monster text and then whichever one she responded there. That was the main 3 floating around. They have seen more than those 3.
Okay.
It's 4 phone screens worth of text messages that still have redactions on them. So
No. Those are from September 2022,
okay,
right? I was talking about those text messages that she sent him uh on the 25th. You remember there was
I don't know. I don't
they
know if that
never
came in
talked
as
about
evidence,
those. Yeah, they never
but
talked about those
it's
text
in the
messages.
911 call,
Yeah.
and they wanna listen to that. Although, to play devil's advocate, at the end of that 911 call, he does say something about keeping this confidential when he's speaking to the first responders, which, I mean, anyone with common sense should sit there and be like, "Alright," then he goes and grabs a blanket to cover his ex-girlfriend's bottom. So, who wouldn't want to ask for confidentiality when something embarrassing is happening to another person, really?
Mhm. And we
But
didn't really hear what I didn't really clue in on that. I'm glad you mentioned that, but I remember him saying it. Well, what was he talking about keeping confidential? Do you remember, or was just
so he was like, it was like they just walked in because it was like it was approaching 4 minutes into the call. And it's when the people on the 911 call, the EMS on the 911 call is still like,
Mhm.
are you there? Are you talking to the police? Are you there? Are you talking to the police? So they're talking over him. But he's like, and keep it confidential, please. But obviously, like that could have just been about the address.
Yeah.
Like you don't know what that actually means. But there is a possibility that maybe a juror will sit there and say, "Oh, he says confidential on this 911 call." And then this other text messages, he says, "Don't tell anyone." But that's why Priya Chaudhry argued, why would he call them? If that was the case, he already called them. There is no confidentiality about the call being made anymore.
Right. Right.
So it just takes a common sense conversation. And that's why I don't think, people want to do a good job. Even if I sat there, I'd want to discuss my reasoning. So if you think a jury should go in, sign a piece of paper, and come right back out, that's just really not how people work. People don't want to be that person that someone could come back to and say they didn't do their due diligence when this is
Right.
their responsibility. This is their moment to do something.
Right.
But
All right. All right, y'all. We're not gonna stay long because, like I told y'all, I have to go to work at noon. Uh, we all want to thank Kat for coming in and giving us all this great information as she has. Again, we're verdict watching. I see you all out in the chat, so I'm going to ask you, how many charges is three charges that they have against him, or four? Four. That's
Four,
the
but they're like reckless and intentional split between assault and then harassment.
so it's
So one
reckless.
reckless, one intentional, one reckless, one intentional for assault and harassment.
I see. I see. I see. Yeah, they're probably. I see. I think, like you said, they want the appearance of doing due diligence and things like that. That harassment charge that they have listed out is the one that, to me, is like, I don't know how they're going to think about that with him
I
pushing.
think that's the one they need clarification on,
Yeah, I don't know how they're going to wreck, but
which is
I am.
hilarious because that means they don't buy the finger injury was caused. But if that's the case, if we're reading the tea leaves right, they're not attributing that finger injury. Even if it was caused in the car, they're not attributing that, I don't think, to being Jonathan Major's fault.
I
So
had,
I think
yeah,
they're asking about the harassment.
yeah. I had said, when we saw the video and then there was clarity about how his home was laid out, and I'm looking at, okay, all those tequila shots, all those stairs.
And how she heard the suitcase, but not the knocking, because the suitcase was on the first floor.
Yeah, yeah. I
So
you know
how did she hear that, but
I
then was
really wish,
asleep?
yeah, I really wish Priya would have gone down that timeline,
That was the last witness, Elon Rispoli. That was his purpose, was the timeline. We got
good.
up there, the 10:45, 11:07, 11:13. Police officers arrive. By 11:20, they're upstairs in the room already, but they get to the lobby by like 11:17.
Right,
So
right. Good, good. Because I was like the timeline, because I'm also looking at the fact that I remember someone saying something about she had either texted or she was speaking to her friend in London about now, was this in the testimony, or was this just something that someone that oh, he may have tripped over the suitcase,
that was to
and
Holly Blakey.
yeah, so did she say that or did she text it?
I'm not sure, but Holly Blakey testified to it. So
Okay.
it's in evidence. Essentially, it's in evidence that during that time, and remember, that could have only happened after 10:45 because that's when he arrived. So she heard him trip over the suitcase and then was locked in the bedroom on the closet floor whenever he got the door open with the handyman.
Yeah.
And whenever he called 911, that was like what, 11:11 or 11:12 or something like that,
Right. So
11:13.
they got into the closet. They see her on the floor. He tries to wake her. He move her? He touch her or something like that? She wasn't awakening. She wasn't moving.
I don't even know if there's testimony about that because it only would have come from him or
Yeah.
her, but she couldn't testify to it because she was saying she was unconscious.
Right. So
So
she had to have seen them. If she had just texted, she had to have heard the knock. She had to have seen them come in. Do that little one eye, like I'm knocked out, but I can
mhm.
see you. And then probably thought he left with the handyman, uh, and then thought and didn't really think by the time he came back that there was going to be so many police officers.
That's the only way I can make it make sense, Pam.
I just anyway. I'm hoping not guilty all across the board. I'm hoping not guilty all across the board, but I do see that unless they get uh great jury instructions from the judge in regards to that harassment charge, that they'll split the baby and say, okay, for this particular charge they'll find him guilty, not guilty of three charges, and find him guilty of that one charge, because one of those charges is like a violation or a fine or something like that. It's a violation or a fine.
I will fight the media battle when they try to make a big deal out of it if that's the case.
Yeah, it's a violation or fine. Do you anybody have any questions for Kat or me? Here, I see this. Hold on.
Yeah.
The last message was on 11:07 a.m. and 13 minutes before the cop came, and she testified that she was unconscious the whole way through with cops waking her up. So she went blackout KOD in less than 10 minutes. Yeah, yeah, yeah. in the chat, tell me what you think, guilty or not guilty. There are 4 charges. If you want to split them out with the 4 charges, or if you just he's guilty on all 4 charges, or if he's guilty just really, really quick. And I'll put some of those up on the screen. And again, this is Verdict Watch. I may come on after work. I think some people are going to be doing lives after 8 o'clock, so I may come on with or jump in some other folks live around that. So the next time you all will see me will be tomorrow, which is Saturday. So jumping in lives or doing anything like that. Let's go. Hold on, let me see. Not guilty, period.
I would love to see it.
Not guilty on all charges. Just wanted to say that you're beautiful.
Thank you. Aw.
Oh. 2 guilty, 2 not guilty. Hold on, let me real quick. I don't understand why she woke up crying when there was no reason to wake up crying.
Oh, I would probably cry too because it's over. Like, it's done. You just got broken up with, and now you got to talk to police. I'd
Yeah.
be in shock. I wouldn't lie. I wouldn't continue to go on and lie, but I'd probably just cry and be like, leave me alone. Please just leave me alone. There's nothing happening here. Just go away. Like,
22. Not guilty. Not guilty, but he needs a new lawyer. You must have quit. Not guilty. Sue all in New York. I see some not guilties. Here's one good one. Not guilty on 3, but I think the 4th one he have a guilty to appease both sides. Yeah.
can you imagine if we have to keep doing this because they have to take it to an appeal, Pam? Because I'll be here.
Yeah.
I love appellate law. I love appeals. So
Yeah.
don't want to see it though.
Yeah. What happens if the charges are split? Yeah. Let me see. Not guilty. Keita says not guilty. Goodness. Not guilty. Victor Thomas. I thought that said Victor Timely. Not guilty. Not guilty. All right. I thank you all so much for joining. This is my verdict watch. We are going to be here to watch and see what the verdict is going to be. If they're not going to start really deliberating for maybe like
2:15.
3:15, and then
because they got to hear the explanation again. Probably they get told
Right.
something, they go home, they're probably going to be like, can you do that one more time?
Right. So that yeah. And they're going to be in there until they come, don't they have like a considerable amount of time that they can deliberate through the evening?
Yeah.
Yeah.
They can ask to stay later.
Okay. That's what my question was, because I know that they were very on point about getting out at 4:35 or something like that. So, all right, people. We do this every week. We want to thank Kat for coming in, and I want to thank all of you for coming in. I see on my screen it says 213 of you all are in here. Please hit that like button for me. Please, please, and thank you. Hit that like button for me. I can't see. I can't see how many likes are hit on that like button. Can you see? I can't see. But hit that like button for me. I really, really do appreciate it. And again, we do this every week. Please tell your friend, tell a kin, tell your coworker, tell that heifer that you can't stand that I'm over here making these videos, y'all. All right, people. And as always, bye-bye.